So this week we are looking at chapter 9 and 10. We're looking at traditional contracts as well as e-contracts. I'll be honest, I'm not going to spend a ton of time on e-contracts. They're very similar to the traditional contracts. So the definition of a contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. Contracts are voluntarily entered into by parties, and we'll get to that into what voids a contract in just a little bit. Terms of the contract become private law between the parties. Obviously, the law governs that private law, but there is no government entity for the most part on the other side. So we're looking at an offeror. This is the person who makes an offer to enter into a contract. And then the offeree, that's the person that it's offered to. Those are two parties when we start a contract. We're looking at elements of a contract. First, we start with an agreement. So those two people, the offeror and the offeree, have to agree to enter into a contract. There must be consideration or some sort of item bargained for in exchange. There must be a lawful object. It can't be illegal or unlawful. And both parties must have the capacity to enter into a contract. Oh, my coffee's hot this morning. Anyway, let's look at the elements. So, an agreement, the offer by the offeror and the acceptance by the offeree. Mutual assent, so there's an agreement made. Consideration, the parties must be supported by bargain for consideration that is legally sufficient. So, it can be money in exchange for services, money in exchange for goods, service in exchange for service. So you fix my toilet, I will wash your car. It can really be anything as long as it's bargained for in exchange. And then contractual capacity. Parties must have the ability to enter into a contract to make it legally enforceable. Minors or persons adjudicated to be insane do not have that capacity. The lawful object must basically, anything can be entered into for a contract as long as it's not illegal or against public policy. So you can't offer into a contract to sell your children. It's illegal and against public policy. You can't sue someone for them not following up on a drug transfer. Obviously, it has to be lawful. There must not be any duress, undue influence, fraud, and it must be in writing if the contract is over a year in duration or over a certain amount of money, and we'll get to that in just a second. Common law. We have two types of law, let's start there, that deal with the contract law. Common law, which is developed primarily by state courts, that is going to oversee any service agreements. The UCC is going to deal with anything with the sale of goods. The restatement of law is a compilation of model contract principles drafted by legal scholars. This is used as a framework of law by the states, but it is not the law that is binding within the state of California. The objective theory of contracts means you intend to enter into a contract, and there must be a reasonable person standard used. So would someone of the same age, work history as the individual entering into the contract logically do the same thing? We can look at words within the contract or conduct and surrounding circumstances. Courts in e-contracts are going to apply traditional type rules, so we're not going to veer away from that. We do look at the UCITA, though, which is basically establishing the Uniform Information Transaction Act for e-commerce contracts. So we have two types of contracts we can look at. A bilateral contract just means the individuals on each side are both doing something for the bargain for exchange. So this is a traditional type contract. I'm entering into the contract for you to buy 500 widgets for $500. The widgets are $1 each. A unilateral contract is a little different. This is the offer can be accepted only by performance. So you call up a paint company and you say, I will pay you $500 if you paint my fence by 5 o'clock on Friday. They don't need to call and accept the contract, but if your fence is painted by 5 o'clock on Friday, you owe them $500. Their actions are the acceptance of the contract. Formal contracts are what we look at, just a special form of creation. This is going to be like contracts under seal, negotiable instruments, letters of credit, anything like that. Informal is what we normally think of, like leases, sales contracts, rental agreements. A valid contract just means it meets all those essential elements: the bargain for an exchange, offer, agreement, contractual capacity, and legal object. A void contract is a contract that has no legal effect. Neither party is obligated to perform, and neither party can enforce the contract. So if you are contracting for the sale of methamphetamines, this is going to be a void contract. A voidable contract means one or both of the parties can avoid contractual obligations by voiding the contract. This can be something as simple as the amount of money is wrong in the contract. Both parties didn't intend for it to mean they contracted for 500. It says 5 million. They're going to void the contract. Now, if both parties wanted to go forward with the contract, they could. Obviously, one party is going to not want to do that. An executive contract is a fully performed contract by both parties, and it is complete. We don't see these a lot in court because they're complete. They're fully functional contracts. An express contract just means it's expressly written or verbally confirmed by the parties. This is different than an implied in fact contract, which means it's inferred by their conduct. So they're following through, they're exchanging money. You can infer that they intended for the contract to go through. Now, let's say two parties enter into an agreement, but there's no implied in fact and there's no express. But one party would be unjustly enriched by the contract, meaning one party would get something for nothing. They would be in a much better position than the other party. The law can imply a contract within court and impose it. The Taco Bell Corporation is a great example of this. I love this commercial or this case because it has to do with the Yokiro Taco Bell dog and the acceptance of Taco Bell. Even though they did not confirm acceptance, they began using the Yokiro Taco Bell dog. Wrench LLC sued them for the rights and won. Equity is a little bit different. This is a doctrine that permits the judge to make decisions based on fairness, equity, or moral rights. No jury trial in an equitable action. The court just will affirm the equity. Hopefully that helps. As always, guys, email me with any questions and we'll move into chapter 10.